Okay, good afternoon, everyone. I'd like to welcome you to the seminar today. This is the seminar on virtual hearings, and as it is now, we have our panelists very ably on ground, and we have a plethora of people joining, and I'd like to thank you all for taking out time to join us here. As we're well aware, today is the 21st of May, and it's quite some time since we have been experiencing the COVID-19 pandemic itself. It has brought to the fore a lot of, so to say, situations that hadn't been before now expected. And due to us in the judiciary and those of us that are practitioners, as are the majority that might be here, we have been beset with the seemingly unforeseen situation or circumstance whereby we have not been put in our arena where we could go in and engage with our daily activities of pursuing the law. And it brought through into the fore a lot of innovative activities that needed to be done, of which were the practice directions that were being brought up, as novel as they are, about virtual hearings and the possibility of the prosecution of justice down the line. So at this point in time, I would be yielding the floor to the principal of Part Solicitors to come in and do the opening, whereby he would introduce us and will commence our activity for the day. Thank you all. And as a part of the house cleaning, we are going to be ensuring that all mics are disabled so that the panelists will be able to speak. So before that, I welcome you all, and I'd like to hand over to Mr. Ibrahim so that he may take the floor. So he could give us a few minutes to do that.
Okay. I welcome all of you to Part Solicitors webinar on virtual court hearings, legality, opportunities, and challenges. There's no doubt that the COVID-19 has really changed the world. It has changed the way we do things. It has changed the way even court proceedings are done. And recently, there's a lot of discussions whether the recently introduced practice directions in the various courts in Nigeria are legal. And we deem it important that we take this topical issue and discuss it, analyze and try and make suggestions so that everyone and in the country will know what is happening with the virtual courts hearing. So we have a team of panelists that are going to discuss this very topical issue. I welcome them most especially. Particularly, I welcome Mr. Onyekachi Uma. I welcome also Ms. Miriam Abdulkadir. I welcome Mr. Edwin Enegedu. And I think last but not the least, I welcome Mr. Akinwa Olu. The session will be moderated by my learned friend, Mr. John Denide, who will guide us through and will guide the panelists towards navigating the topics. I hand now to Mr. John to take over from here. I welcome all of you. I hope we will have a nice session.
Thank you, sir, for such an interesting opening. And as it stands, we have our webinar open at this point in time. And just as he has rightly set the tone for the webinar, we've already come into the COVID-19 pandemic. It is a reality where we stand in, and it has put the judiciary in a spot, and it has put us legal practitioners in a tight band on how we are to go about engaging in the business of law. First off, we'll be starting off with our lead panelist as Ms. Miriam Abdulkadir, where we'll be looking at the issue of virtual hearing. And at this point in time, I think we'd like to ask the basic question: what is a virtual hearing?
Thank you very much. Good afternoon, everybody. I hope everyone can hear me.
I believe so.
All right. All right. Well, to answer your question, virtual hearing is um, let's say, sort of a digital revolution, if I might say so myself. It is where you have court proceedings, being done online using technology. That is what I mean by a digital revolution going on now across the globe. And this is not the first time that we're having, virtual proceedings actually happening. A lot of countries across the world, even before now, have advocated for virtual proceedings. Countries like China have been doing it since 2015, where they have, artificial intelligence, and other technology mediums, handling court proceedings and virtual conferences for court proceedings, and even including, ADR, virtual conducting ADR processes virtually, and this form of court proceedings, of course, has sparked so much, concerns for these countries that have started since before now. But with technological advancements, as we will soon discover, they have been able to tackle such problems associated with virtual proceedings. It's a very interesting venture. It's a very interesting new order, for the digital system globally. And the main reason why most of the countries have been doing it before, before COVID-19 or before the pandemic, is because they found out that there's a lot of backlog, and when it comes to dispensation of justice, there's a lot of problems, there are a lot of issues involved with, let's call it physical court. Since we're talking about virtual court proceedings now, let's what we are used to, let's call it physical court proceedings. So the physical court proceedings, they are now, they've discovered that there are lots of problems. Like I said, we will discuss that further. So they have advocated for virtual proceedings. So basically, in a nutshell, virtual proceedings is when you use technology, to conduct your court sitting or court proceedings and processes included.
All right, thank you so much. To Barrister Onyekachi, the aspect I would like you to shed some light on would be, considering the realities that we have right now, can you enlighten us on the need for the adoption of this novel aspect of practices here in Nigeria, considering the realities we have right now? Because by the practice direction that have been given and the template that has been set right now, the virtual hearing is here as a reality for us, but what are the aspects that we need to take into consideration as we proceed into the virtual proceeding reality that we are coming into now?
All right, thank you very much. I have gone through about 4 to 5 practice directions, from Lagos to FCT High Court, the Federal High Court, then Enugu State. One thing that comes to mind first is, do we have adequate legal framework for us to have a virtual hearing? And my answer is in the affirmative. Looking at Section 36, we have the needed legal framework for us to have a full virtual online hearing as it is. Well, from what I see now, I believe that this is long overdue. Unfortunately or fortunately, it appears COVID-19, the coronavirus, has prompted us to take the big leap. Although so many other countries are already in this. Looking at cost of being a lawyer, cost of going to court, everyone gets seated 9 o'clock, court may not sit. There are a lot of issues that all along there has been a cost. Why ordinarily Nigerian judicial system should have been running on a virtual system. Now, thank God to coronavirus. Now, as to what I'm seeing so far, so many of the practice directions are, apart from the Federal High Court, so many others are limiting their practice to cases that are based, the evidence, affidavit evidence based. You know, I understand the fears of the courts, because when you are taking oral evidence, it's expected that a judge must observe the body language of a witness. That may be said to be the issue why they are running away from making it general for all cases, you know. But from what I believe that all the cases, like when you have issues of fundamental human rights enforcement, originating summons, originating motions, and the rest, those are not issues for virtual hearing. They're not. Those are issues for emails. Send a mail. If I send a mail to a judge, I have an expert, I've put in my papers. He downloads the mail. He reads the authorities there. He sees the evidence there in the affidavit. Then he sends in a judgment. So I think we're celebrating over nothing. That's my own take. So if you look at, okay, come to issues of originating motions, originating summons, there's no need to call evidence. Take it to appeals. Today we go to Supreme Court, we go to Court of Appeal. They will not even allow you to add on bread for 10 minutes. When you start, they say, is it a new issue? If it's not a new issue, please just adopt and walk away. So what is the essence of dressing up, going to court to adopt? Those are issues matters that one should just send via email. You send it via email, the judge or the registrar downloads. The judge will read through, see the evidence, see the argument of counsel, then make his ruling on that. If there's need for any issue to be clarified, he will send a mail requesting for gray areas to be handled. Now, if you agree with me that all the issues that we have selected to the issues for online hearing are actually issues that should not even be for online hearing. Rather, let me call it electronic hearing, wherein you just email and go. Now, the main issues that should not be for virtual hearing are issues that need oral evidence, highly contested issues. We can't be running away from the reality. You know, where like they said, the train has long gone. You know, now if you look at the Lagos, I think Lagos State was very fast. Lagos State brought out their own practice direction 4th of May. It was as if it was going to cover everything. Then maybe due to the fears I mentioned earlier, they ran back and brought out another one on 15th of May. That is practice note 2. Practice direction number 2, sorry. Now that practice direction number 2 only states that the issues one can put on virtual hearing are matters that are affidavit evidence based. You know, now Federal High Court came out with its own wonderful legislation, that practice direction. However, it has not stated that issues that can go to online hearing must be affidavit based. Not at all. It just said that once parties agree, counsel agree, then they can proceed to that. So for me, this is the best we have presently in Nigeria. However, provided that we don't have the Federal High Court rushing back in some weeks' time to give us a practice direction number 2, wherein they will now make it issues that are affidavit based. Now, someone will be asking, how will the judge or the judges be able to get the body language of? Come on, in cross-examination, even examination in chief, the way you are seeing, you're okay, apart from hearing me, you are feeling my gesticulations and all. Now, if we make it a condition sine qua non for hearing that the video must be set on a particular angle, an angle that shows you the full size of the witness, I believe that a judge will be able to understand, feel that same net, because this is real time. It's not pre-recorded, it's real time. So you will still feel the same stuttering, stammering, or facial, so many other things that you want. You it on real time. See the beauty of this. When there is a hearing on Monday after the hearing on Monday, the judge may be writing Monday, October 19. The judge may write judgment on Monday, October 2022, 2 years after. I can tell you for sure that there is no human being that can actually understand, remember, and have those things as fresh as they were when he took evidence. But when we're doing this, when we're doing it online, the court can have them recorded. Now, 5 years after the judge wants to write judgment, all he needs to do is press play, and he still sees the nature of a witness. So why are we running away from these issues? Because the difference between us here is just we're not in the same place. But I can imagine Miriam being a witness in Lokoja. I'm counsel in Abu.
And that's one of the problems. That's one of the problems, network issues. We've lost him.
So this is where we can go. As to the core issues as they were, there are a lot of them. I believe I don't just want to give out challenges without solutions. So I have pointed out about 15 issues, which over time we will get to see, and I can send in even after the program.
All right.
I know that network would maybe an issue, but I'm proposing that there is need for a counsel comes in to say, I want to use electronic or online. It is assumed and presumed that he has a reliable network. Because you see a situation where a counsel may not know what to do during litigation online, and he just does, hello, 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 can you hear me? Can you hear me? He presses off and he goes his way. He has frustrated the process. So there is no way the court can know the attitude or the intention of a witness or even a counsel. So when you agree to have your matter had online, as a matter of fact, these have the same issues because these things are online based, they are remote based. So many issues, they can be a truncation from any point for any reason whatsoever. The only difference is the margin is higher over here compared to other places. Then the NBA duty for young lawyers, there is need to provide virtual hubs where people can go into, sit, and because you have a lawyer who is in Suleja or a young lawyer who is in far away, remote places, and he wants to sit in a matter. All he needs to do is come to the bar center. The bar center will provide you uninterrupted power supply, uninterrupted internet service, and you hit up, you know. Now, over time, we start thinking of having direct, having cable-based networks so that level of interaction will be lessened. Dedicated trunks. You imagine a situation where these dedicated trunks are actually connected between the bar centers and the courts, say Abuja, the FCT High Court and the Federal High Court, so that the level of disruptions will be reduced. That's all. There are a lot of issues. We have issues of even sabotage. We have issues because we're relying on a third-party service here. You know, so there are some folks who can hack into this system. There are some people that can disrupt a whole system as it were. Now, I think in all the four or five practice directions that I've considered, everyone is saying Zoom, Zoom, Zoom. But if you look at, if you ever imagine that you may not be in Zoom of Nigeria is running on the platform of an individual who pays allegiance to another sovereign state. So that can cause a lot of issues. A place like China can shut down your judiciary, your system in a day. So over time, we should be talking about having our own custom-made platforms. I should be able to log into FCT app, maybe through a blockchain, which is very safe. And all I'm having, everything there is a bespoke, is custom made for hearing in what do you call the options? The options there will be quite different from the options therein for what you call a witness thereabout. So there are things they cannot do, but we can do. So you can't have those. Look at, you can't have such services if you keep relying on WhatsApp, on Zoom, third-party softwares. No, we're not yet there. You know. So there are a lot of litanies and all. Now another thing is publication. What we're having here now, and even the press can come in here. And the press can munch the screen. Even a counsel, not even a press, anybody can record what we're doing. And imagine this is hearing, a court hearing. And just 1 hour after the hearing. So the issue, when we look at the challenges, there are a lot that has to be done. When we have a custom-made platform, it will be impossible for lawyers, it will be impossible for counsel, the lawyers, and participants to munch technologies as they were. Then it will also be professional misconduct. Okay, if you look at their order 21 and 22, it's all about recording procedures. Before a counsel can record a procedure, he must do that with leave of court, you know. So there are litanies of challenges and issues we will face. That is life. And since law is organic, as they come, the law, the practice direction, even the new civil procedure and criminal rules will keep changing as they were. Also, let me quickly end on this note. I have seen some publications with some writers being of the view that criminal trials cannot be held online. That's a lie. If you look at section 36, 3, 4, 5 down, you will notice that the only requirement there is that this should be done in the public. What is public? Public, I think I would like to,
if I may, sir, that's where I would like to dive in and throw that to Barrister Negedu, because we were working towards that section.
It's not.
Hello, sir?
Oh, okay. So, all right. Okay, so that's fine. So I believe this is just a nutshell on challenges that we face. As time goes on, I will show the remaining 13 points.
All right. Thank you so much, sir. On the aspect you rightly led us to, that was the fulcrum of the whole issue we've been having in the general discussion space. The issue of public. What is public? The definition of public as we have it within our books, the letters of the law. Because the argument has been that, yes, as much as the virtual hearings that we have on ground has been brought in to make life a whole lot easier, to ensure that justice is not truncated, we find ourselves with the technicality that is coming into play, whereby most of our legal practitioners may want to exploit that seemingly large gap, as we like to look at it as in every practice, direction, or law, because it is the staple of every lawyer to look out for the seemingly large loopholes and still exploit it to their advantage. So to you, Barrister Negedu, I'd like you to expand more on the possibilities of how this section 36 sub, as has been referred to here, can be tackled to ensure that the definition of public does not truncate a novel, what they call it, tool that has been made available to us as legal practitioners to use in our activities. Barrister Negedu.
Can you hear me?
Yes, I can hear you.
Yeah, can you hear me?
I can hear you.
Okay, great. First, let me say hello to my co-panelists. The first point I need to make about this, if you permit me before I go to my question, I just want to give a brief background too, by saying that in other climes, like the United States of America, being on the front burner since the late 90s, and all of the challenges and the issues we have thrown up now, are also issues that they have considered before arriving at where they are today. So those fears are legitimate, and they are real if we want to look at it from that perspective. Now, I'm starting with the issue of the constitutional inhibitions being touted by a lot of persons. The essence of the virtual hearing itself, it's not something that takes care of all situations as it is now. If we want to look at it from the perspective that what we have now is a knee-jerk reaction to an uncommon situation. So we'll now understand why we need to take it from where we are and then move along with it gradually. But essentially, the issue of section 36(3) and 4, I do not see them as a hindrance to the remote or virtual hearing as it is. Starting from the perspective that the issue, if you look at the Constitution, it says in public. It says in public. And if we want to understand what in public means in respect of a court proceeding, even our physical court hearings, the courts are open. People go in there, people follow them. Now, from the practice directions I have seen, the directions from NJC to FCT and all of them, I think adequate provisions have been made not to restrict the public from having access to what is happening or the hearings. Now, if you look at the position from the NJC was very, very clear that the sittings must be in a courtroom, which is similar to what we have in the physical court sittings. Now, the cases people have challenged, Menakaya, Edibo, and State, all these were instances where the sittings were held in chambers. And most of us have had issues with proceedings in chambers which were not deemed to be open. Now, the point about the issue of in public, essentially, is not that you go to a market square and hold a sitting. That is not what the situation is. The setting has always been a courtroom. And for as long as the directions were very express, that even if a court is going to sit in chambers, it must be with the permission of the head of the court. So for as long as the sitting itself is in a courtroom itself, where normal court proceedings take place, it qualifies as a public sitting. Now, besides that, the FCT directions even went further to make provisions that the meeting ID, the invitation should be sent to lawyers and their clients, as well as same being placed on the website. Despite, though, my personal opinion is that that provision is too wide, because you're simply giving notice to the whole world to come for a sitting. And if that sitting is a very delicate one, it could be Zoom bombed, just like Onekachi pointed out. A lot of other things will happen to that kind of sitting. So I personally think, in as much as we want it to be in public, there should also be limitations. Now, this is more particular for the fact that there's a proviso to 36(4) of the Constitution, which enables the court to also exclude persons from the proceedings. So, sit in public itself is not an absolute, it's not an absolutism. There are limitations, which is also in that same Constitution, which is 36(4), the proviso to it. So, based on this, on the provisions of the directions I have seen, I think the directions have made adequate provisions for sitting in public. Now, it doesn't even end there. The NJC directives even went as far as saying that a court can sit if a judge is marooned somewhere within these circumstances. That's why I started by saying that it's a knee-jerk approach based simply on the COVID-19. Because if we had considered it from the perspective of my co-panelists, that these are a nature of proceedings that had been going on in other jurisdictions even before COVID-19, then we'll understand essentially that ours is just. Sorry, can you hear me?
I can hear you. Please proceed.
Okay, great. So now the fact in our own situation is that it is in response strictly to COVID-19. So, and that is why I agree with Onekachi that look, we need to look beyond the COVID-19 interregnum as it is now, because it cannot take care of every situation as it is now. So, but in terms of what the directions are, they are actually in terms with the provision of the Constitution. Yes. Now, why I said this is because two things. One, what are the nature of proceedings that were covered by the remote hearings? To understand what, like the FCT, Lagos, all of them are limited to affidavit-based or non-contentious, or strictly said non-contentious litigations. Now, if we want to look at that, you go through the NJC directions again, you will find out that it is explicit that it refers to matters that do not require taking of evidence. Personally, for me, just like Onekachi said, I have been of the view long before now that some sittings, some court proceedings should not be physical. But at every point in time we try to raise these issues, people tell you that you cannot deliver judgments, you cannot deliver rulings unless it is in public. So now, what we have now, even besides the issue of even besides the issue of the emergency we are now, it is also not possible to have a court sitting differently from what we have even physically. I don't know whether you follow my point.
Yes, it's
the
very,
point
yeah,
is this:
going.
court sits, a judge's business is in the courtroom. So if he sits virtually from a courtroom, it satisfies the provision of sitting in public.
Sorry to interject, sir, but there's in line with what you just rightly said. If the judge were to be sitting in the chambers and being projected through whatever medium is chosen, if I got you correct, you're putting it that would suffice as the definition of public, since that would create the atmosphere of having a courtroom.
No. If you look at the case of Menakaya, the judge sat in chambers, and that was why the Supreme Court said no, it did not. That case, that was not an authority or did not qualify for a hearing in public.
Sorry, it's one of the
hello?
I think one of the things that has been contemplated as technology gap in the issue of network connectivity is affecting us in the course of this program. So
yes, we'll get to that, and we'll also talk about those ones too. Now, the point is this.
Sorry, please, could you? Yes, sorry, it's clear. You can go on.
Okay, now, I still want to go back to the practice directions again. I made that point very clear.
Yep.
That the practice direction is expressed, especially the directives of the NJC to all the head of courts. It's very clear that the proceedings must be in a courtroom. It goes beyond that. If a judge is going to sit in chamber, if a judicial officer is going to sit in chambers, it must be with the approval of the head of that court. But like you pointed out now, it just got me thinking as well too. I'm sitting in my office now. If I create the background, or looking at your own background, which has a lot of law books behind you, it creates the impression that you're actually sitting in a court or somewhere. Everyone knows that those books behind you is not the sitting of a court. It's not the court setting. In my office now, it is not a court setting. I can see Miriam, I can see Mr. Ibrahim. These clearly are not court sittings. So, and due to the fact that these proceedings are recorded, it is very easy to decipher whether it is a court, whether the sitting was held in a courtroom or not. So I am not saying that sitting in the chambers equates in public. No, that's not my position and that's not my view. My view is strictly based on the directives and the practice directions that it is expressed that judicial officers must sit in courtrooms. If, for any reason, they prefer to sit in chambers, it must be with the approval of the head of that court.
Thank
and
you.
I think that satisfies the provision of sitting in public.
All right, sir. Thank you very much, sir. One of our panelists just came on, Mr. Olu Akinola. We'd like to welcome you on board, sir. As we have been, as it stands right now, sir, we've come to the crescendo where we've been analyzing the positions of the virtual hearings that we have before us. What obtains and what will be the most apt manner in which the courts could be defined and how proceedings could be conducted therein. So at this point, we'd like to throw open a few questions we'll be taking in questions on the slide. So as many questions as you have that come to your mind, please, to the participants, you can use the chat function and put down your questions for us to tackle along the line. So at this point in time, I'd like to rehash the caliber of persons we have here so that we can actually have an understanding of our speakers, because we started this whole discourse straight into the meat of the issue without having you introduced to the speakers in person. So without much ado, at this point, I'd like to get us to understand that we had a very, very, very robust set of panelists that started this discourse with us. We have with us Mr. Adakole Edwin Enegudu, who is a senior legal practitioner who has been sharing us a lot of views on what we see with the virtual hearings, and he has been opening up to us the various views that he has for us on what virtual hearings are and how we can adapt it to our everyday activities. And we have just really joining us right now, Mr. Oluburio of he is the founding partner of Stone Waters Law Office. That is Mr. Oluburio Akinola. He is the founding partner of Stone Waters Law Office in Lagos. So bringing into perspective what Barrister Onyekachi Umah had actually been giving us into review here, we'll have the benefit of bringing in another client, which is Lagos, that had their various practice directions 1 and 2 discussed earlier on. And Barrister Onyekachi himself, as we all know, is a very, 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 very prolific writer and speaker himself. Being a practitioner of renown himself, he has also been into human rights activities, especially in the area of human rights enforcement and intellectual property. All of our panelists, as we have them here, have been taking on the issue of virtual hearings in the current climate that as we have it, the challenges and the opportunities. So at this point in time, I'd like to call on Barrister Akinola to give us the perspective from outside the jurisdiction of Abuja on how the proceedings on virtual hearings have come into play in our everyday activity, bearing in mind what Barrister Enegudu had been talking about, the issues of practice directions and the applicability in our everyday activities. Yes, sir.
Yes. Can you hear me?
We can hear you, sir.
Okay. Good afternoon, fellow panelists. And I want to thank the Pathway Solicitors. Thank you for bringing me on board. Essentially, I think the issue of remote hearing is a matter that has become, that we can no longer shortcut. And all we just have to do currently is to see how we can bring the current practice or the current situation that we are in line with the existing law. Because when you look at the Constitution, essentially, I've not been able to listen to my learned friend who spoke earlier. But I know that section 36, subsection 3 and 4 are the basic issue. And the issue there is that these sections say that we have to have public hearing. And in a number of cases that we have had, public hearing has been defined as public having access. Let's even say we can go on with remote hearing or virtual hearing. What is the constitutionality of the proceedings that are had through virtual hearing? So I think that is where we are all now, and that is a concern that, okay, if these proceedings.
It seems Barrister Kinola is experiencing some technical difficulty. Some of the things that we have been discussing at the fore here on the issue of connection and the way it affects proceedings. I would, at this point, probably direct our discourse to Barrister Miriam, where we were talking about, after looking at the issues of the practice directions that we have before us. Barrister Miriam, we're going to be the introduction that we have of this before I even get to Barrister Miriam to take us further on the issues we have at hand. Barrister Miriam herself is equally a lecturer of the Faculty of Law Bayes University. You might wonder why we saved her for the last, because they always keep the best for last at this point. Barrister Miriam herself is a lecturer at the Faculty of Law Bayes University here in Abuja, and where she teaches clinical courses like clinical moot court and practice. So we are bringing into play her specialty as a supervisor of the Bayes Law Clinic, where they have been able to take in most of these things that we've been looking at and preparing the young generation to get ready to come into the general practice of doing law within the new climes that we have. So before us right now, looking at the peculiarities of the practitioners, we want to find out how we can go about this in a practical manner. I think, hold on, before we proceed, I think Barrister Olu is back. Okay, I think we still have issues with connectivity. But nonetheless, we'll still proceed. Looking at the peculiarities of the practice directions that we have right now and the engagement of legal practitioners in differentiating between non-contentious issues and contentious issues, because as much as we are looking at it, there's going to be will I say, inevitable abuse of the platforms as we see it. So we'd like to hear your own take on what it would take for practitioners as we are right now, both young and aspiring, how they can manage themselves online on the issue of the etiquette in this new climate of virtual hearings.
Okay, thank you very much.
Sorry, your mic was off.
Okay. Yes, like I was saying, you know, one of the most difficult things to do is to initiate a new order of things, because with the new order of things comes a lot of skepticism, especially with stakeholders. And stakeholders here, I mean the judges, the lawyers, and the litigants, or the parties, as you want to call them. And I think when it comes to ethical issues, you know, let me just piggyback on what Barrister Oikachi said. In that practice direction of 2020 of the Federal High Court, you know, they highlighted two issues that have to do with ethics. The first one is that the virtual hearing will not go on, you know, without the consent of the judge and the counsel, sorry, the consent of the parties. That's one. And then two, it also mentioned that the judge and counsel must be robed and for all issues at all times. you know. So just showing us that even if the proceedings are remote, we still need to adhere to ethical issues in the profession. And most importantly, the ethical issues that we need to really uphold are, you know, first and foremost is your relation with the client, which is part D of our practitioners, legal practitioners rules of professional conduct. You know, the diligent aspect of handling your client's case. Because it's remote, because we are using virtual platforms, does not mean you should be lax. Somebody talked about background. You should not be on your you should not be doing multiple things because you think nobody can see you. You should not be seen as not being diligent, you know. And then I mentioned the issue of dress code, where we've had a lot of issues coming up, you know, with this digital revolution, where people dress anyhow, you know. So these are just some of the ethical issues, and most importantly, your relation with the court. You shouldn't be on top of. I'm just giving examples here. You shouldn't be on your bed and be addressing the courtroom, you know. I think that is why the practice direction of 2020 of the Federal High Court is telling us that we should, the judges and the lawyers should be robed. And I also want to just touch on the attitude, because you mentioned, you know, young lawyers, how we're supposed to approach this whole issue of virtual proceedings. I just want to talk about the attitude of all the stakeholders here, not only just young lawyers. Now, it has to do with, you know, the reason why people are skeptical about the virtual proceedings, you know, is because of the issues that have already been highlighted, the problems associated with virtual proceedings. For example, security and privacy, you know, and there's also the issue of lack of training. A lot of people before now don't know how to handle, you know, Zoom or Google Meet or any other platform that allows you to do virtual proceedings. And then there's the issue of funding. There's the issue of funding, you know, data. You know, my colleagues will tell you that, okay, I'm using my data. Will the client give me data allowance? Since I'm not going to court today now, my transport allowance will not be converted to data allowance. So issues like that, and okay, you have unstable power supply, poor internet provision as we have it. You know, I know that some of my colleagues in courts like to use, you know, the trial strategies. During cross-examination, they would like to intimidate some of the witnesses, especially during cross-examination. You can imagine trying to intimidate a witness, you know, asking rapid questions just by way of trial strategy, and then the connection goes off. So you lose that effect on the witness. You know, so lawyers are skeptical about virtual proceedings when it comes to that. And the parties are also being very skeptical, you know, when it comes to virtual. Giving her testimony, she was giving her testimony, the judge was there, she could see her lawyer, she could see the jury, she could see everybody, but she felt, you know, so distant from reality. So expressing herself, you know, became difficult for her. This is the litigants now. I'm talking about the parties of the litigants involved. You know, expressing herself became very difficult, and she couldn't bring herself to believe in the system of virtual proceedings. So that is how, you know, it affects litigants as well. And also when it comes to you know, there's been arguments that how do we tender documents and so on and so forth. So these are just some of the issues that have been highlighted. But like I said earlier, when I was defining virtual proceedings. It is a digital revolution. All these problems that we are seeing, you know, like Oyekachi has rightly mentioned, there needs to be progress in these problems. He has mentioned something very interesting: bar centers and hubs, where you have, you know, constant supply of electricity and data. So that will do with lack of, you know, the issue of funding and unstable power. And then because of their security issue and what have you, some people can hack into Zoom. It's been argued that some people can hack into Zoom. There's no privacy, you know, and litigants are also afraid of online trolling, because if somebody can hack into a virtual proceeding, you know, and look into, maybe know about your matter or issue, you know, they control you online. So this is also one of the problems. But like I've said, these platforms have been, because of demand, they've been trying to see how they can fix these problems. And sorry, I like making reference to other jurisdictions, but hey, it's the reality. Let's learn from other jurisdictions. For example, China now has a dedicated app for the courtrooms, and like I said, they're using I've just highlighted. So just summarize, you know, yes, judges are skeptical because of the like they've argued, the unconstitutional nature of it, which some of my colleagues have already debunked. You know, lawyers are also skeptical because of the issue of the whole security, privacy, lack of training, funding, etc. Litigants are also having cold feet when it comes to such issues. But like I've said, you know, there is high demand for virtual proceedings, and I believe that these things will be fixed along the line. And then secondly, when it comes to ethical issue, I don't think any of the professional ethics we have can be suspended in this for virtual proceedings. All of them, especially your relation with your client. And I talked about being diligent in handling your client's case. Not because you're online, that doesn't mean you shouldn't be diligent in handling your client's case. And then your relation with the court. Like I said, you need to conduct yourself properly online, just as you will if we were in the physical court. So these are just some of the things that I wanted to highlight.
All right, thank you so much for your presentation, Barrister Miriam. So just, I see Barrister Akinola is back online, so we'll be cycling back to him now, because based on the discourse, there was a position that was brought forward that Lagos State had already passed two rounds of practice directions, that of the 4th of May and the 15th of May, and the realities we have going forward for virtual hearings. We'd like to hear your perspective on this as well, sir.
Yeah. Hello?
Yes, it's open, sir.
Okay, thank you. You see, I think when you look at the jurisdiction, Lagos is far ahead of other jurisdictions in terms of before in some of our hearing. Like personally, in our home office, we've had to conduct hearing abroad in Court of International Arbitration using remote hearing, digital hearing, even before now. So we have some lawyers that has been using this thing. So, but the question demands that you can actually conduct matter in the Constitution. Is it envisaging virtual hearing in this sense? So we have to look at all the questions that people are now raising. But for me, as far as I'm concerned, I think the diligent thing that we have to do as lawyers, we have to work at this time, and we have to. Hello?
Yes, you can continue.
Okay, we have to work with the legislature at this time and make sure that there is an amendment to the Constitution If we have that amendment, then everybody can now look at the logistic. My sister has talked a lot about the logistic of actually conducting virtual hearing. Because when you look at the logistic, you have to look at the cybersecurity. You have to look at, is it safe to pass some document through virtual hearing? Can it be hacked? Is it safe for the judge? Is it safe for the litigant? Is it safe for the lawyer? These are things we need to look at. Because when you now talk of virtual public hearing in the virtual sense, it then means the whole world can have access to that court online. And when I say the whole world, I mean the whole world in the true sense of the whole world. You have the hackers out there, you have the stalkers, cyber stalkers out there, you have all different manner of people out there and what they can do. If they have interest in that case. So these are the things we need to, the scale we need to, what we need to scale first is the constitutional scale, this constitutional order, so that if the constitution is amended to meet the reality on ground, that, okay, public hearing can be conducted if people can have access to virtual hearing, it has complied with the public hearing, or it is directly stated in the constitution that, look, you can do virtual hearing through the digital means that we are now proposing in Lagos State. Then everybody, the idea of the constitution, whether it is constitution, I've read a lot of pieces from buyers arguing the constitutionality and the legality of this proceeding, that they will challenge it even at higher jurisdiction if Lagos State even start all these things. But it's not even the issue is that if you conduct it, good. What is the power of the rule vis-a-vis the constitution? A rule has been set. Just this week, Lagos State just signed another rule 2020 into law in order to come in compliance with the COVID-19 era. But the question is that, what is the legality of the proceeding conducted under that rule vis-a-vis section 36 subsection 3 and section 36 subsection 4? Does it mean public hearing provisions? And we've had a number of decisions by the Supreme Court where public hearing has been defined. So, and when you look at that definition, access is public access is the meat of that definition. Then when you look at public access, can people really have public access? Can the public actually have access? Access means they don't have to buy data to access. They don't have to get all this infrastructure to be able to access. If they need all this infrastructure to be able to access, then access may be denied. Because when you look at how many of us in Nigeria as we speak that are having smartphone, mobile phone, you begin to look at the enormity of the problem. When you look at many of us that are even having access to the internet, it is still less than, even in Lagos, it's less than 50%. And when you take Lagos percentage, it's not like that across the country. When you go to places like Ondo State, you go to Ekiti, you even move up and up, this percentage will start coming down. I'm not talking of phone now. People may have phone without having smartphone. So these are issues. And people may have smartphone without having internet connectivity on it. They may not be able to get data. So they may not be able to afford it. So these are the questions about the logistic of actually conducting virtual hearing. And I think the lawmakers will put all these things into perspective in amending our laws to comply with this era. Because this era has been forced on us. When we look at this era from 5-10 years ago, we've been hearing about digital hearing, and actually some of us have been privileged to actually had it conducted. And immediately the COVID now switch into digital hearing, and because they are prepared for it. But our problem here is that we are not even prepared for it yet. Now, I think that is one of the reasons why the noise is all over. We are not prepared for it. The populace is not prepared for it. We lawyers, we are not prepared for it. Because for us to actually have a serious virtual hearing where we are going to conduct trial, the requirement of the Evidence Act, you do digital filing. Then how do you put people on oath? This factor in, but I know these are logistics that can be taken care of by technology, but it will take time. But all we need is a move towards amendment of the Constitution, and then a move towards installing and building this infrastructure, because we need a dedicated, like my sister said, a dedicated infrastructure for digital hearing to actually take root in our system and become the new normal in this dispensation. That is the way I see it. And the rules that are coming up, of course, they are telling us about how to file when proper filing is deemed that you have properly filed. So, and all of us have to look at it and see how we can now put the required infrastructure for you to be able to file. Now, you must have very good scanner, fast one that can connect directly with the court server. There are some offices that have very good scanner, because you will need scanner. You would need to scan your documents and turn them into digital format to be able to send it to court through digital filing. Then also the payment system. We now need to be paying. We look at the security of that payment process. Can it not be hacked? So, and I think these are these challenges that we are yet to perfect, even in Lagos, the issue of payment system. Now we need to file by paying, because if you don't pay, your filing process may have issue. And these are the issues. We need to make sure that we have a dedicated payment system that will take care of the court. We should not rely on this current payment system that we have, the general payment system whereby you pay through the InterSwitch or other payment portals. So we must strive to have a judicial payment portal in which we are going to be paying directly from our office, so that place you can be sure of the security of the payment system through the web. Now, moving away from that, we have to also look at the witness. Now, in this dispensation, it means witnesses have to come to the chamber during trials. So how do we make our office comfortable for a trial proceeding? Is very key. Is the witness going to take his own system and I'm going to take my system and connect to the Zoom? Or we are going to have a digital board in our libraries or in our meeting rooms to have this done? These are costs. We are trying to install this week. And averagely, if you want to install a digital board of the standard that we do virtual hearing, you will spend about $500,000 just on the average. It may be more than that. So if you have a bigger office, depending on the number of people that we attend, we also determine the kind of expense you are going to make. Then how many offices will be able to afford that? So these are things we have to, because if we are doing anything, it should be expenditure that average law office should be able to afford. So these are things maybe government or the judiciary will have to come and factor and support law firms to be able to achieve this, because that, I think, is still going to create obstacle for us to actually migrate to that virtual platform. If I have it and the other party is not having it, then that other party may not be able to present its case very well in accordance with the Constitution. The Constitution, Section 36, is talking that you will have right is a fundamental right. Right to facility. So facility now may be interpreted in the light of the virtual facilities. If you are going to conduct my trial virtually, then of course the facility of that trial, I must have access to them. You must have access to time. You have fundamental right, time, facilities. I think that's what the Constitution is trying to say. So if it could be stretched, we can say that this virtual thing we are talking about is also a fundamental right of litigants before the court, that they will be able to conduct their case and defend themselves under the law. So, and I think it's a serious matter, and it's a serious matter for all of us. Looking at essentially the challenges, constitutional challenges, of course, despite the challenges, we have certain opportunities. And when we look at the opportunities, it gives us, we now have an environment in which we can actually have smaller offices. We can have, talking from the employer's point of view, a lot of things can now be done electronically without necessarily, you don't need to go to court to go and do a lot of things you need staff to do, support staff to do for you. You can now actually use technology to do some of these things right away from your office. So from talking from an employer's point of view in the system, it may actually, the cost of installing this digital system may be high initially. The initial cost outlay may be high, but immediately you install it, of course, the cost over a period of time may come down. And because it's going to, you can't install technology into a system and you still have the kind of labor force you have currently, whether from the office or from the court system. It's going to reduce the labor force we are currently having. And that is another challenge for the economy. An economy that is grappling with high spiral unemployment. Of course, technology, if we are forced to go the way this COVID-19 is pushing us to go on virtual, is going to reduce the work, the staff requirements for chamber practice, and of course for our court hearing processes. So,
sorry to interject, sir. So that's to say that, drawing from your inference now on the issue of technology coming in to advance, it will also bring in, so would I say, a downward slope in earning power, because as firms will have to adopt new technologies to adapt to the realities we are walking into, there is that likelihood that if you want to ensure quality is attained, there might likely be a downsizing of manpower in order to ensure that proper equipment and proper sensitization is achieved before we can actually adapt to some of these realities we are going to be living with.
Yes, because currently I'm attending a course online, and the course I'm attending online is on this digital disruption of business. Is being run by Cambridge, and currently we are doing artificial intelligence. By the time you go into those courses, even as a lawyer, you know that if you are going to use machine to replace a lot of duties in this age, it will get to a point in which the firm may be as smart as small, and yet we have a lot of big coverage, yet with smaller staff, smaller space, and many other things that will come into it, which of course, it has its negative side. The negative side is also to compound the unemployment problem that is already in the system. Then there are other challenges.
Through with the time we have, and there are a few questions that have been put out for us to respond, sir. So I'll be craving your indulgence at this point so that we could attend to some of those questions for the speakers to try and tackle as well. We'd like to appreciate Mr. Akinola. He has really expanded on the realities we have that are coming into our practice, especially the adoption of technology, showing us that technology, though it is an assistance to us in the course of doing these virtual hearings, it would bring in some realities of downsizing and adaptations that firms have to do as we go into this new reality we have. Thank you, sir. There's a question that was put forward, and I think it was directed to Barrister Negedu and also Barrister Zonyekachi. So I think we have, since we are pressed for time, we'd like to use our word, adumbrate, and go straight to the questions that are there. There was a question that was put saying, that was raised by Mr. U.H. Usman, Barrister U.H. Usman, from SAF and Sanderson. He was asking, in a situation where we have fluctuations in data, in network, what can be done? What, let me take it especially, what provision is in place to address this issue of network service fluctuations so that litigants or parties cannot be shut out of the proceedings? Secondly, there was another question that was given by Mr. Gerald Ajoku, asking that, looking at the case of Menakaya as cited, that borders on the case of matters not being held in the public, but rather that the judges should sit in chambers. What is the legality of if a counsel who has agreed that their matter be held in a judge's chamber, and what that he was, if I get it correct, what is the legality of holding a sitting in a judge's chamber? Does that go against the idea of public sitting? So I think I'll put that open to Barrister Negedu to try and tackle in 1 minute or 2 minutes, sir.
Okay. I think the position is in Menakaya is very clear. The Supreme Court expressly said that the fact that the proceeding was heard in chambers renders it null and void. So I think the person who asked the question didn't really get my first perspective. The point is, if you sit in chambers, it is null and void, it's not public. That is why I refer to the practice direction of from the NJC, that the direction is expressed that if you must sit in chambers, it must be with the approval of the head of that court. So that's one. Two, in Menakaya, both parties agree to sit in chambers. You understand? Both of them agree to sit in chambers. But the Supreme Court laid down the principle that was where the Supreme Court laid down the principle that parties cannot agree to set aside a constitutional or legal provision. Because that was the argument of one of the parties there. One of the parties went to the Supreme Court and said, no, my lord, both of us agreed that the judge should sit in chambers. But the Supreme Court said, look, you cannot agree to set aside the provision of the law or the Constitution for that matter. So in that particular aspect, Menakaya did not meet the provisions of a hearing in public. And that was why the trial court's decision was set aside.
Thank you very much, sir. Sorry to interrupt. Just as I said, considering the fact that we are about rounding up at this point, we'd like to appreciate everyone who has taken out time to join us for this webinar, and no doubt we have raised a lot of novel issues and topics on ground. So at this point, I'd like to hand over the management, the closing remarks to Barrister Ibrahim, who afterwards will take a few closing remarks from our speakers. Thank you.
Thank you so much, everyone, for attending. I'm sure we all take away, we have taken away a lot from the discussions from our erudite scholars and legal practitioners. Thank you so much, especially Ms. Mariam, Mr. Umar, Mr. Enegedu, and Mr. Akinola. You have really done justice to the topic, and I appreciate your inputs. I also thank everybody that attended and participated in these discussions. Thank you so much. We hope to see you soon. Have a nice time. Maybe Mr. John, we can take more questions. I think the time is
Time is up, and I'd like to thank each and every one of you who has taken out time to attend, especially our panelists who attacked every angle of the virtual hearing that we had in mind, and also brought to the fore a few issues that most of our practitioners and I myself did not avert myself to. We have the issue of the economics of the virtual hearing, and also the practicalities of the practice direction, and also the ethical issues that have to do with dressing and approach to hearings when we have our lawyers and ourselves coming up on board. So with this in mind, we'd like to thank you all and ensure that this will not be the end, but there will be more series coming out in times to come. Thank you very much for attending, and we bid you adieu.